Hi, and welcome to the NLHA channel, where today we will be looking at the matrimonial property regime system in South Africa. So this week, one of our clients sent in a request to know whether it is possible to change the matrimonial property regime and what the procedure would be if they would like to change that. So the client is married in community of property and they want to change it to something else. And we will be discussing whether it is possible in South Africa, and if it is possible, then how do we go about changing the matrimonial property regime? So first off, we need to understand that the default regime in South Africa is being married in community of property. So if you do not have an antenuptial contract signed or entered into prior to being married, then the default position would be that you are married in community of property. So that's the default if you have not entered into any agreement prior to the marriage. So in South Africa, we have three matrimonial property regimes, and I'm not going to discuss in this episode the differences between the regimes, but it's just something that we need to take note of, that there are three. So to change your property regime, so for the example, let's say that we are looking at a couple that is married in community of property. They do not have any antenuptial contract. So to amend or to change the regime that you are currently in, one has to consider the Matrimonial Property Act. So yes, there is an act, there is legislation that guides the marital property regime. So in terms of the act, both the husband and the wife can apply jointly to the High Court to have their matrimonial property regime changed or amended. So it's a joint application that needs to take place, and take note, it's in the High Court, so you can't go to the Magistrates Court or any of the lower courts for a marital property regime change. So it should be noted that it is not an easy process to change your marital property regime. There are specific requirements that must be met and that must satisfy the court before a court will grant an order for such an application to change or amend your marital property regime. And I'm going to look at only a few of these which I've highlighted as the most important, but it's not an extensive list, just to give you an idea. So to answer the first question was whether your marital property regime can be amended. The answer to that is yes, it can. The second question was the how, and as already stated, the how is regulated by law, the Matrimonial Property Act. So if we look at a few of the main requirements, first of all, the court wants to see that there are sound reasons for the proposed change. So you can't just go to the court and say, listen, I'm married in community of property and then I want to be married outside of community of property. It doesn't work like that. So you need to provide sound reasons as to why that change is required. The second important thing is that the change should not prejudice any other person, whether it be a creditor or anyone else. The change should not be prejudiced or should not prejudice any other individual. So the rights, for example, of creditors must be preserved if there is a change in the matrimonial property regime. So for me, that is the two most important factors and the most difficult that one has to overcome when you apply to court to have your marital property regime changed. There are also other factors apart from the two that I've just mentioned in terms of the law specifically, and these are more procedural. So for example, that we've spoken about creditors, but you need to give notice to all creditors that there is a proposed change to your marital property regime so that they can comment on that. Also, there must be a notice of your application to the Register of Deeds that you are changing or proposing a change to your marital property regime. And then also, there must be publication in the Government Gazette, and I think 2 newspapers, I think one Afrikaans newspaper and one English newspaper, and these must be done within a prescribed period in terms of the Act. So couples approach the legal practitioners thinking that it's quite an easy aspect or process to change a legal property regime. It can be, but in most cases it's not. It's not that easy, and unfortunately we also find that it's not cheap. So it's an expensive procedure. The key point to take from that is to make sure that before you get married, that you are aware of your marital property regime that you want to enter into. Like I mentioned, one of the key factors for me is that the applicants must meticulously explain why no other person will be prejudiced. A lot of couples try to do this on their own, and you must note that this is not allowed in the lower courts. It's a high court application, so it's not an easy process. Rather seek legal advice, and if you can, use a legal practitioner to move the application for you. If you have any other questions, legal questions, please use the information in the description below and send us your question. We will try and answer it as best we can. For now, cheers. Bye bye.